And Manoj, there has been some, if I may say so with great respect, perhaps misunderstanding of what our position is. There is no denudation of power in 50. Let's be clear. Denudation is of the regulatory power of 23 because of the declaration in the MMDR Act.
Can you just take that again? The denudation
is not in entry 23 power or the field.
Right.
Yes.
There is no overlapping tax power in our two entries. We once came very close to this in the luxury tax cases, as they were called, the hotel receipts tax case, where the aspect theory got injected. And fortunately, it was given a healthy burial in the Godfrey Philip case. Unlike the Canadian Constitution, we divided our legislative fields neatly, cleanly, acknowledged where there is overlap, and that is why 246(1) says notwithstanding and 246(3) says subject to. And tax entries were compartmentalized. And a very good example of that is entry 84, the excise duty. Union list excise duty on everything other than alcohol for human consumption. State list originally excise duty on alcohol for human consumption. So our tax lists are neatly divided. Knowing all this, the founding fathers said, a tax on mineral rights subject to limitations imposed by Parliament, first of all. It's the only entry in which Parliament limits a taxing power of the state. And those words have to be given a meaning. And how are these limitations to be found? Imposed by Parliament by law relating to mineral development. And I'm not respectfully adopting what the Attorney General has argued. This phrase, law relating to mineral development, must, like all legislative entries, be construed in its plenity. A rather narrow view of this, saying there must be a section in the MMRD Act saying you will not impose a tax, or you will not impose a tax more than so much, is perhaps too narrow a view of the Constitution. So we do not need to say if something goes out of 50, where does it land in entry in list 1? No, it doesn't. And why was this done? Justice, those very important point my Lord was pleased to ask was Mr. Palkhiwala used a very interesting expression in this courtroom. The resources of a state are niggardly compared to that of the union. When we were arguing that the union tax on hotel receipts was unconstitutional, the state tax was valid. Never forgotten the expression, niggardly resources of the state. But there was one problem with mineral rights. And this is a serious problem in the federation. Our mineral resources are not evenly endowed. Some states are much richer in mineral resources than others. And yet, the economic development of each state has compelling need for minerals. North India, not so rich in other things, doesn't have minerals. Central India, in Maharashtra, we used to have coal to a small extent near my hometown, but not much. Now, look at Orissa, look at West Bengal. God has been, they have abundant resources. Karnataka, great amount. You go further down to Kerala, you find nothing. So, nature, when God created land, He didn't draw these boundaries, He have drawn these lines. So, not all states are equal in resources, and this in the past has been the cause for great friction between kingdoms. So, the framers, right from 1935, when the Government of India Act first recognized this, it said provincial government may impose mineral tax subject to limitations imposed by the federal government. This has been a matter of grave concern always. And this whole matter has to be viewed in that context. As I said yesterday, ultimately it's a question of seeing the balance between entry 50, entry 23, and entry 54. And as far as 23 and 54 is concerned, I don't have to reinvent the wheel. Right from Hingir Rampur, Bajnath Kedia, Tolok, they have all explained how these two laws sit with each other, and I'll be taking a lot of through those 3 or 4 cases. And as I have in my opening indicated yesterday, what did we argue in India Senates? And this has troubled the court, be it the Patna judgment, be it the Mysore judgment. If you have excessive royalty, one state is rich in a particular resource, it has a very high rate of royalty. There are industries in another state which require them minerals. You're creating economic stress. So Parliament says you will not have more than so much royalty. And very interesting, My learned friend argued yesterday, Parliament can't usurp the power. You're right. 9 doesn't usurp the power to royalty. 9 says, you, the state, recover this royalty, but not more than so much. So the resource remains with the state. It doesn't become a union resource. Now, if Parliament says you should not have more than 50 rupees per ton, I'm just taking an arbitrary figure, of royalty, or 5,000 rupees a ton of royalty on, say, iron ore. You say, all right, I have 5,000 rupees a ton of royalty, and then I have 300% tax on mineral rights to extract that royalty. The limitation on 9 is meaningless. And that's one of the crucial passages in India Cement about, are you not indirectly increasing royalty? You're negating the limitation imposed by Parliament on royalty. And some of the laws, I'll show you, Lordship, state tax on royalty.
By doing what?
Suppose we say 300% tax on royalty paid. You say 30%, you say 300%, you say whatever percent. So I am allowed royalty of 1,000 rupees a ton, I take that, and then I have 300% tax on that, so 3,000 rupees by way of tax.
But Parliament can still enact a law that your rate of taxation shall not include this cap.
But is 9 not that law, is the point. And that is what India Cement looked at. When you see the conspect...
Actually is not a restraint on tax, because royalty is not tax. I think we have all...
It doesn't need to be.
That royalty is not tax. In which case, the cap which Parliament imposes under 9 is a cap on royalty and not a cap on tax.
I'm sorry.
Even today, Parliament can come out with a law saying that, look, we don't want any state to have taxation of more than, say, 12% or 28% on royalty.
Malad, your Lordship has
to absolutely do it as a
Malad, of course. Does not 9 fulfill is the point which your Lordship...
That's the heart of it, really.
And I'll tell my Lord, there's a whole analysis which is underlying this submission. Yes, my Lord, prima facie, it does look that Parliament should say you can't have so much tax. But there are so many different models of tax. So if Parliament fixes an exaction, is not royalty an exaction? My Lord, I'm not using the word tax. Because the basic difference which came in India is because of how the English altered land tenures in India.
Section 9, which provides for royalty rates or cap, is an exaction which has been imposed.
It's an exaction. And tax on mineral right is also an exaction, albeit in the form of a tax. The difference on tax on mineral rights and royalty will be, and I made bold to say so, where the state is not the owner of the mineral. And we still have some small areas where some minor minerals don't belong to the state. The state has nothing to do with the minor mineral or the mineral. Mr. A, a private person, is exploiting the mineral. He's not even giving a lease. He's digging up his own ground and taking out mineral. You can say, all right, I tax you on this, on your exercising your mineral rights to extent. Or A gives a lease to B. As we have so many cases, one are decided by your lordships, decided by high courts. State can say, I'm not exacting anything, I'm imposing a tax on mineral rights. Now, where the state itself is the owner of the resource vested in it for public good. We have now long abandoned the theory that the state is like any private owner. That ship sailed long ago. Your lordships in RNRL and Reliance went to the extent and say these are all these, the mineral wealth is held in trust. And that is why these elaborate provisions. And once your lordship see the current trend of the legislation on how auctions are held, how prices are fixed, it's a complete fit. Now,
Mr. Salve, you're saying where the state is the owner of a resource,
owner of the mineral,
vested for public good.
Vested for public good, it is all royalty itself becomes the exaction. And if you say no more than this, then you can't sidestep that. Then that itself is the limitation. And this is never going to happen to major minerals, but maybe in minor minerals, we have seen some of the minor minerals are decontrolled. The state says, all right, you let the private people deal with them. The moment that happens, the legal character changes. And Parliament may not want to limit that. If Parliament says no more than this much tax, then public or private, that tax is frozen. Because, my lord, please see what a question which my lords have asked 3 times, and the answer lies in the question. It has to be as a facet of mineral development. The limitation must not be, I don't like your face. I don't want you to burden poor industrials. It has to be as a facet of mineral development. That's very important. That's in 50 itself. You can't generally limit as a resource limitation. It has to come as an integral part of a law which limits mineral development. How will that come? If it was not a general, in fact, as the Chief Justice pointed out, some entry says subject to a law made by Parliament. Not any kind of law. The Parliament can make any law and knock you out. But when 50 says by law relating to mineral development, that means the limitation must be an integral aspect of mineral development. So when we see all this, that is how your lordships will have to look at it. So to get to this, and that is what how our submissions are treated in your lordship's judgment is another matter. It's put in 2 sentences in India Cements. You cannot do indirectly increase royalty. This was the submission. And the submission, actually, since I have only less time today, let me just digress. The submission about the contradiction, as I said yesterday, had nothing to do. The judgment is dealing with 2 completely different points. Justice Vanchu's dissent in English, and I'm going to read that to you. The majority, say so in all humility, was clearly right. They said a tax on mineral produced, the quantity of mineral produced is a measure, the taxes on mineral rights. He said no, the moment you put it with reference to mineral produce, it becomes an excise duty. So it's unconstitutional. And the next sentence he says that royalty can be a tax on mineral rights. But royalty itself is with reference to mineral produced. What it was saying is, if that is so, then royalty is not a tax on mineral rights. If something with reference to mineral produce is an excise duty, it doesn't metamorphosize when you call it royalty. I mean, it's either excise, it's wrong to say it's excise. With great respect, the majority didn't accept that. And nobody has ever even ventured that line of reasoning here.